which is not actually really the idea of the regulation and initial initiative of the MiCA regulation. And I think that those cases may end up at the court, because finding the real legal basis to basically say we are not accepting your license from, let's say, Malta, it's very difficult, but we all understand who are providing the advisory service and having the experience in the traditional financial market, that finding the reason to reject the application for the financial institution is not very difficult. So you have a lot of possibilities for this, starting from the, I don't know, safeguarding, background check of the shareholder, not proper structure, not enough measures for the risk determinations, etc., etc. So it's interesting time. It's very interesting for the market players. It's an alert, a signal that they need to take into account, because basically, of course, if you are a cusp against which the, let's say, Italian regulator is taking this decision, you have your basic right to protect your rights in the court. But for other market participants, this is just a signal to think once again in which jurisdiction you should be regulated. And reputation of the country, the court system, the tax system, they are still very important questions. It's not only about the regulatory regime or opportunity to get a license easier or faster or something like that. It's always about the complex understanding about the risks involved with the particular jurisdiction and reputation of the country as well. And maybe another important point over here is, like, I hope that the situation will be maybe somehow waived by the communication of the national authorities, roundtables, etc. However, for the market participants, it might cause a situation when your business activities will be shut down in the particular jurisdiction. And let's say if you do have the cusp who is working with the Italian market, and this is 30% of your or your client base, this is huge, and it might be a reason of the bankruptcy or insolvency. So this is a very very dangerous situation for the market participants, and they should be aware of the particular tone of the national authorities and approaches, how they are reacting to the let's say licenses from the other jurisdiction. Additional point regarding the gossips for me was that we see that jurisdictions who were very strict in terms of the approach to the cusps in last let's say 2-3 years, but having the experience with such industry, are actually now taking very carefully the application and providing the quality feedback for the market participants. What I mean, if the regulator is having the previous experience with the fintech in general or crypto industry in general, they will be able to understand which kind of risks this industry has, what are the biggest problems, what are the biggest misunderstandings between market players, consumers, and regulators, and it's easier to address it based on experience that they have in the past. And especially if we are talking about what is happening now in Estonia, we do have the positive tone or positive signals from the Estonian financial conducting authorities, FSA, who took the approach of transparent communication, which is very positive for the market participants.